The immigrant detention system is a disaster. In the past 2 decades, the federal immigration detention has grown dramatically, with over 400,000 people locked up each year, about 5 times the number detained 20 years ago, at an annual cost of more than $2 billion. That cost is just the money to run the jails. The human cost, what immigrant detention does to the human beings behind the bars, is incalculable and immoral. Immigrant detention is not supposed to be punishment, but that is exactly what it has come to be. At least 141 people have died while in immigrant detention during the last decade. The problem with the U.S.'s immigrant detention system is that too many people are being detained, and they are being detained for too long, and that the wrong people are being detained. It is a problem of over-detention and prolonged detention. During the past several years, litigation by the ACLU and others in such cases as Damore, Tijani, Casas Castrillon, Leslie, Diop, and Rodriguez, and others, has created an opportunity for fundamental change in the immigrant detention system. Recently, AILA filed 2 briefs with the Attorney General, asking him to issue 2 nationwide decisions that would go a long way to fixing the immigrant detention system. This podcast describes the arguments in those briefs. The first brief asked the Attorney General to interpret the general detention statutes to resolve the problem of prolonged detention by adopting a rule that states that none of the general detention statutes authorizes prolonged detention. Once detention is prolonged, an immigration judge is required to hold a prolonged detention hearing, where the government must prove by clear and convincing evidence why continued detention is necessary. The brief defined prolonged detention as detention that exceeds 6 months. Here's how the argument works. The argument is based on 2 main principles: the canon of constitutional avoidance and the interconnected nature of the detention statutes, sections 235, 236A, 236C, and 241. When the canon of constitutional avoidance is applied to sections 235 or 236 of the INA, the so-called mandatory detention statutes, the statutes only authorize detention without an adequate hearing for a short, brief period. AILA's brief suggests 6 months as the maximum. Once detention is prolonged, then those statutes no longer authorize detention, and the Attorney General's detention authority shifts to section 236A. Under 241A6, the authority to detain without an adequate hearing after a removal order is entered ends at 6 months as well. In both pre-removal order and post-removal order cases, the brief asserts that at the 6-month mark, or sooner in some cases, the Attorney General should order a prolonged detention hearing for all non-citizens still detained under Section 236A or 241. Because remember, at the 6-month mark, no one would be detained under Section 235 or 236C. A prolonged detention hearing has 3 key features. It is an adversarial proceeding before an immigration judge. It is contemporaneously recorded, and the DHS has the burden by clear and convincing evidence to prove why continued detention is warranted. This is the rule adopted by the District Court in the ACLU's Rodriguez litigation. AILA asked the Attorney General to adopt this rule nationwide for all non-citizens in every detention center. The second brief was filed in the case called Matter of Aguilar-Aquino. In that case, the BIA had interpreted the word custody to mean jail. AILA makes a different argument, though, in its brief to the Attorney General. AILA argues that custody does not mean confinement, though it could include confinement, and it asked the Attorney General to adopt AILA's position nationwide. Under AILA's interpretation, most of the individuals in immigrant custody today could be placed under house arrest, electronic monitoring, or other alternatives to jail. Here's how the argument works. The argument relies on two principles. First, the control concept from a Supreme Court case called Reno v. Correa, and second, the statutory structure of the detention statutes, sections 236A, 236B, and 236C, that would define control as the operative principle of custody. The argument essentially says that the difference between Section 236A, permissive detention, and 236C, so-called mandatory detention, is, of course, 236B, the revocation provision. What that means is that the difference between being in custody and out of custody is whether the DHS has complete control over the non-citizen, not the type of control. Jail, or as the term the brief uses, confinement, is just one type of control. There are many types of control that are possible, such as electronic monitoring, daily supervision, or curfews, to name a few. Here are two examples that we used in the brief to illustrate how custody as control would work. Take an LPR, who is convicted of a crime involving moral turpitude rendering him deportable. He is eligible for LPR cancellation of removal. And at the conclusion of his criminal sentence, ICE exercises its Section 236C1 mandatory arrest authority and, quote, takes into custody, end quote, the non-citizen. ICE completes a notice of custody determination on Form I-248 that could reflect that the non-citizen is subject to Section 236C1 and therefore is not eligible for release. Under AILA's argument, ICE should then make a second determination regarding the most appropriate conditions of custody for this LPR. Using similar factors like those already widely used and familiar in the 236A2 context, an ICE officer could determine that because this particular LPR has resided in the United States for a long time and has a nonviolent criminal record, that confinement in a detention center is excessive and unnecessary. Instead, the ICE officer could issue an order setting forth the conditions of custody that place the LPR on a biweekly in-person reporting requirement, using an electronic monitoring system and a daily telephone reporting requirement. Should ICE later determine that the conditions of custody were overly onerous, or, on the other hand, insufficient to maintain assurance, ICE could summarily modify the conditions of custody by merely notifying the LPR of the modification. In short, the individual is in custody, as he is required to be under 236C, because he is completely subject to DHS's control. On the other hand, take the example of a different non-citizen who is inadmissible under 212A6A1 for being present without admission or parole. This non-citizen has limited family ties and a poor work history in the United States. Accordingly, he is not a good candidate for conditional parole under 236A2B. Instead, DHS could release him under 236A2A with conditions such as biweekly in-person reporting requirements and using an electronic monitoring system, conditions that are identical to the custodial conditions of the LPR in the previous example. Although both individuals are subject to the same terms, the difference lies in DHS's complete power to exercise control over the LPR under 236C1, whereas if DHS wants to change the terms of release under 236A for the undocumented individual, they must first revoke the release and re-trigger his right to an IJ custody redetermination hearing. You can read the briefs on AILA InfoNet. If you search for amicus briefs, you can see all the briefs filed by the AILA Amicus Committee. To follow other podcasts about immigrant detention, you can go to www.legaledweb.com/immigration-law. And if you have an interesting case that raises novel issues of law, you can let AILA know by emailing amicus@aila.org.